Good evening, students. Good evening, everyone. Okay, any volunteer, please confirm about the voice and the video. Namaste, Ladli, please confirm about the voice and the video. I'll start the session. Okay. Thank you, Millie Jan, for the confirmation. Thank you, Mrigang Jan, for the confirmation. On that note, let's begin with this class. So, first of all, I welcome each one of you to my class on the conclusion of the Indian Contract Act 1872, Part 2. So let's start with my brief introduction first. My name is Sandeep Khatri. These are my areas of specialization. As you can see on the screen, the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, I have shared the link of my profile of Unacademy. So make sure you follow that to get all the updates about my special classes and my plus courses. I've also shared the link of my Telegram channel where you can connect with me and ask questions in relation to judicial preparation. At last, I have mentioned my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app, and also to get 10% discount for all the plus courses. So it was about me. Let's move further. So I request everyone now please be attentive, and this is going to be an interactive session. So the moment you feel you are not clear with anything, feel free to ask any questions related to judiciary in the comments and I'll answer accordingly. So what we are going to do today, yesterday we completed the conclusion of section 1 till section 75. So basically we are already done with section 1 to section 30. So I'm going to cover the next part, that is from section 31 till section 75 today. So before starting that, if you have any questions in your mind, you may ask, and if not, quickly give me a thumbs up. I'll straight away start with the next part, that is section 31 till section 75. Yes, please. Very good evening, Kirti. Yes, any questions till section 1, from section 1 till section 30? If not, quickly give me a thumbs up. Very good evening, Aprajita. Very good evening, Kanika. So no questions? Good evening, Amit. Chaliye. So in that case, I'll come up with some questions and let's see who can answer those. Okay. My question is, when it comes to wagering agreement under section 30, that is a void agreement. Okay. So there are exceptions of this, but as a general rule, wagering agreement under section 30 is a void agreement, right? Now, coming to contingent contract under section 31 is a valid contract. Now, why there is a difference between these two consequences? This is basically my question, that when it comes to wagering agreement, this is considered as a void agreement. But when it comes to contingent contract under section 31, it is treated as a valid contract. Even in the cases of contingent contract, it is based on the happening or non-happening of an event. So Why such difference? Why wagering agreement is a void agreement and why contingent contract is a valid contract? Yes, anyone, if you can answer me in the comments. It's an important question for your mains examination. Very good evening, Akhilesh, and everyone, those of you who have just joined, waiting for your answer in the comments. I hope everyone is clear with the question. And try to be as specific as you can in your answer. Try to hit the bullseye. Waiting for your answer. Okay, Amit, I have got your answer. रूबी, कुछ होना या नहीं होना? Aprajita, sir, firstly upon legality. Anyone else? Okay. Now let me answer. Now please do listen carefully, students. It's an important question. Now I'm first repeating the question and after that I'm giving you the answer, the exact answer. See, my question was very, very simple that when it comes to wagering agreement under section 30, that is considered as a void agreement, right? There are exceptions, but as a general rule, wagering agreement is a void agreement, right? Now coming to section 31. When it comes to contingent contract, why it's a valid contract? So now coming to the reasoning. The reasoning is, now let's take an example. A match is going on between England versus Australia. Now A is saying to B that if England wins, I will pay 5,000 rupees to B. And B is saying if Australia wins, I'll pay 5,000 rupees to A. Now, this is one of the best example to understand the concept of wagering agreement. Now, it's all depend upon who wins, right? It's kind of a bet. It's a betting, right? Now, if England wins, A will pay 5,000 to B. And now, if Australia wins, then B will pay to the 5,000 to the A. We will consider this as a void agreement. Why void agreement? Because there are no skills involved. First thing first, there are no skills involved. It is completely on the happening or non-happening of an event, right? So if England wins, there is nothing which A or B can do. If Australia wins, again, nothing to do with A and B. So it's basically betting we are dealing with and it's a void agreement. Now coming to an example of contingent contract. Suppose there is a contract between A and B that A will deliver the goods today and B will pay the price. Now A is saying I am going to make the delivery today only if there is no rain. ठीक है जी? If there is no rain today, then A will deliver the goods. And if there is a rain, then A will not be able to deliver the goods. In this scenario, there is happening or non-happening of an event, but that is not something which is important. In contingent contract, our most focus is on this. Contingency is something which is in collateral. But here, our focus is only on winning or losing. Because our focus was only on winning or losing, it will be considered as a void agreement. But here, when it comes to happening or non-happening of an event, that is something which is not about the contract. This is just the collateral. So main contract is this one, and this is why contingent contract will be treated as a valid contract under section 31. If you are clear with this, quickly give me a thumbs up. I'll move to the next question. I hope it's clear. Now coming to the next question. When it comes to life insurance, okay, when it comes to life insurance, whether life insurance is a contingent contract, yes please, life insurance is a contingent contract, yes or no? So suppose in case of life insurance, there is a person, Mr. A, and he has taken a policy from this particular company. So Mr. A is paying some premium, and in case of his death, A will pay amounts to the nominee whosoever has been chosen by Mr. A. So whether you can say that this is a contingent contract, yes or no? Kanika, I'm repeating myself for the wagering one. In case of wagering agreement, it is all about the chance. It is all about the luck. There are no skills involved. The major focus of the parties is of only winning or losing. Nothing else. Nothing else. So we call that betting. And betting is something which is illegal as well. Okay, so that is why we consider that as a void agreement. So let's take an example. In my previous case, if the example was if A wins, so if England wins, A will pay to B. Now let's take an example, England wins. Okay, now if A is not paying to B, can B move to the court of law and ask for the money? Enforcement by law? The answer is no. You cannot enforce that. You cannot claim damages on that. Why? Because it was a void agreement. Reason, there are no skills involved. It is just a matter of chance, and it was betting. And under section 30, it's void agreement. But if the same thing you apply to the contingent contract, in contingent contract also, it depends upon the happening or non-happening of the event. But that happening or non-happening is something which is collateral to the main contract. So I will deliver goods to you only if there is no rain for today. In that case, I'll deliver goods. So there is happening or non-happening, but that is not something which is the main thing in our contingent contract. In the main thing is whether you will deliver the goods or not. Okay, so that is why that's a valid contract. I hope it's clear now. Now coming to the next question. Yes, when it comes to life insurance, whether we can call it a contingent contract. Okay, Kanika is saying yes, contingent. Millie is saying no. What about others? Life insurance is a contingent contract or not? See, if I tell you the essentials of section 31, the very first essential. Okay, now let me give you the test. How will you test that whether this life insurance is a contingent contract or not? The first one, and that is contract. Now, can I say that there is a contract between A and this company? Answer is yes. There is a contract between the person who has taken the life cover and the company who has given the life cover. So there is a contract between these two parties, right? Second one, to do or not to do something. So to do. What is the contract all about? What is the contract of life insurance? That to do something, okay? What to do? To give money to the nominee. Okay. Third is ensure. If some event collateral to such contract does or does not happen. So death happens, if death happens, then the company will pay money to A. Why? Because A is also giving the premium. So yes, life insurance is a contingent contract. And now coming to the next one. Let's take an example of car insurance. Will the car insurance also be considered as a contingent contract? The answer is no. Why no? Because your car insurance or your bike insurance or your scooty insurance will fall under the contract of indemnity. Now the thing is, then sir, if we are talking about insurance, why car, scooty or bike insurance is falling under contract of indemnity and life insurance is falling under contingent contract? The reason for that is because life is something which cannot be indemnified. What do we mean by this term indemnity? Indemnity is basically your security for the loss. Now if some person has if the death of any person has taken place, no insurance can no insurance can basically indemnify that loss. Okay, money is money, but still the life of a human is something which is precious. Okay, so that is why life insurance will be considered as a contingent contract, but when it comes to car insurance, okay, so this is something which can be easily indemnified with money. I hope it's clear now. And if you still have any questions, feel free to ask your questions in the comments. Millie Jan, answer to your question. Yes, that is the reality. The ultimate truth of life is death. I do agree. But whether the death will take place in the upcoming 10 years or not, this is something which is contingency. The death may take place, the death may not take place. So that is why it fall under that contingency. And if the death takes place, the company who has given the life insurance will pay the amount that the amount insured to the nominee. I hope it's clear. Okay, the last question on contingency, my last question on contingency, after that I'll move to the next topic, and that is, when it comes to contingency, can there be a contingent contract? Okay, let me change my question. Can there be a contingent agreement on impossible event? Okay, मैं तुम्हारे लिए चांद तारे तोड़ लाऊंगा, ठीक है? तो when it comes to poetry, that's fine, but in reality we all know this is something which is impossible. Okay, so coming back to this question, can contingent agreement, which is something for completely impossible act, what is going to be status of that, whether we are going to consider that as a valid contract or not? Answer in the comments. Starting from Kanika, everyone is writing no, 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 no. So it will end up as a void agreement because the happening of an event is something which is impossible. Let's take a simple example. So if these are two parallel lines, if they are parallel, obviously they will not intersect. Okay? They will not intersect if they are parallel. And if they intersect, for example, like this, if they intersect, it means they are no more parallel lines. Okay? So as far as the concept from the maths concerned, they will go till they will not meet, parallel lines will not meet, but they will meet on infinity, right? And which infinity means which is never, like. See, as far as the concept of maths is concerned, this is completely correct. But the moment you involve philosophy in it, this may sound absurd to you, right? Okay, so moving to the next one. Coming to the next question, students. Now we are jumping to the next chapter, that is basically performance of the contract. Now answer this. One of the most repeated question in your exam from this chapter is, if there is a contract between two parties, A and B, if there is a contract between these two parties, and the contract is about that A will deliver the goods and B will pay the price. This contract has taken place, suppose today is 29th. So suppose on 20th November, this contract takes place, which means proposal, acceptance, consideration, agreement, section 10, all the essentials have been fulfilled. So basically, as far as the question is concerned, I can assure you this is completely a valid contract that took place on 20th of November. Now, this contract needs to be performed on 29th November. In short, on 29th November, A needs to deliver the goods and B needs to pay the price. Now suppose on 29th November, the performance was due. On 25th November, what if A died? Now what is the status of this contract? Will this contract becomes void? Will it still remain a valid contract or void agreement or illegal agreement? What is going to be the result? On 29th November, what is going to be the result? What are going to be the consequences because of the death of Mr. A? Yes, please answer in the comments. Okay, Kanika, first one to answer, still remain a valid contract. Aprajita, second one to answer, remain valid. Valid, representatives will be bound. Chaliye. Everyone's answer is correct, and that is, students, just because of his death, this will not impact this contract in any form. And on 29th of November, any of the legal heir or representative will deliver the goods of A on behalf of A, and B will obviously pay the price. So the status is going to be a valid contract. But now if I change this question, if A is a famous painter and A needs to paint the picture of B, now what is going to be the status of this? If A needs to paint the picture of B and B needs to pay the price, the contract took place on 20th November. The painting needs to be done on 29th November, but the painter died on 25th of November. Now what is the status of this contract? Kirti, please complete your answer. Void what? Void what? Void agreement, void contract, what? Kanika, contract becomes void. Aprajita, Amit, please complete your answer. Void what? It will become void what? Void agreement, void contract, what? Waiting for your answer in the comments. Okay, I have got two answers, Kanika and Amit. Contract becomes void. Rest, Millie, Kirti, Aprajita, their answer is void contract, right? Now, let me tell you a concept. Step number 1. The whole story starts with proposal. Step number 2. It's acceptance. Step number 3. It's promise. That's the main step. So, mind it. Now, coming to the next one. Once we have a promise, then there comes consideration. After consideration, it becomes agreement. Next, after agreement, there is involvement of section number 10. And after section number 10, this will become contract. Now coming back to my question, students always do remember, if you have reached to the stage of promise, you cannot control that. You cannot undo that. You cannot undo. Once you have reached to the level of contract, you cannot go back and say, now this has become void agreement. This is not possible. And in my previous question, there was a valid contract. And if you are saying this is a valid contract, before valid contract, there can be void agreement. And after valid contract, there can be only contract becomes void. Which means there is no such concept called void contract. You please tell me where the term void contract has been defined. There is no such concept in the whole Indian Contract Act 1872, void contract. There is no such concept, which means the concept is contract becomes void. Now there is a difference between these two things. When you say contract, void contract, it means कि contract खराब है. But if you say contract becomes void, it means this was a valid contract, but due to some circumstances, it becomes void. And in our situation, because now the painter has died, there was a valid contract, but because the painter died, now because of obvious reasons, he cannot perform his promise, and on his behalf here, legal representatives cannot do the same job. And that is why we are going to consider that contract becomes void. I hope it's now clear. If it is clear, quickly give me a thumbs up. I'll move to the next question. Okay. Perfect. Next question, students. Listen carefully. There is Mr. A, there is Mr. B, and they have a contract. They had a contract on 20th November. On the performance is due on 29th November. Okay. Now just assume on 29th November, B needs to pay the price and he needs to deliver the goods. Now on 29th, if A refused to deliver goods, on the date of performance on 29th November, Mr. A refused to deliver the goods. Now, can you force Mr. B? Can you compel Mr. B to perform his promise? Yes or no? Can you compel Mr. B to perform his promise, like to pay price from your end? Amit, first one to answer yes. What about others? Do I need to repeat the question? If yes, please do write in the comments. I'll repeat myself. Aprajita, no. Kanika, no. What about others? I'm repeating myself. There is a contract between A and B. A needs to deliver the goods, B needs to pay the price. The contract took place on 20th of November. The performance is due on 29th of November. On 29th November, A is like, I'm not going to deliver the goods. In that case, can you enforce B to perform his promise on his part, which is to pay the price to A? Can you enforce that to B? Millie, no. Chaliye. Now let me conclude the answer. The correct answer is no. Can anyone give me the section number? That's an important section number, by the way. Everyone's answer is correct. The answer is no. You cannot compel. The reason is again very simple. If A is the one who has committed the breach of contract, then the other party has no duty to perform his promise. If he is not getting the goods, why he will pay the price? So the answer is no. I'll be super happy if you can recall the exact section number from which this question has been asked. Yes, if you can recall the exact section number. $54? No, no, no. 54. Don't remember the section number? How can? It's an important one. Section number 38. 38. 38. Section number 38. Are we done? Can I move to the next question? Kirti, you were close. It's not 39, it's 38. Now moving to the next question. Mr. A, Mr. B, and Mr. C, they had made the promise to Mr. D. So they are basically the debtors. Just a second. D is basically the creditor. And they all three has promised that they will return 30 lakhs. Okay. So D is the creditor, he is the debtor. Creditor is the one who has given money to ABC. Mr. D has given money to ABC, that is total amount 30 lakhs. And ABC, they jointly promise to D that yes sir, we are going to return your money, the complete money. Okay. Now coming to, can I say, my question number 1, can I say there is a contract between these parties? Can we say there is a contract? And the answer is yes, it's a valid contract. Now coming to the main question. When it comes to the liability of A, B and C, that liability is joint or several. Now first understand the question. Joint liability means they have to combinedly given 30 lakh rupees to D, which means 10 lakh each. If we say it's a joint liability, it means 10 lakh each. And severally here means कि even A is liable for complete amount of 30 lakh rupees if B or C cannot return the money. So A has to return the money completely solely. Now answer this. Liability of A, B and C is joint or several? First one to answer correctly, Kanika, followed by Amit. Zara. Okay, Zara has only answered joint. Kirti, joint and several. Here it is jointly and severally. Both. So Zara, please do correct your answer. The correct answer is both. But none of you has written the reasons. Why? Why both is the correct answer? Come on. The reasoning is not written in the bare acts. Joint or severally, that is completely correct answer. Now can you please give me the correct reasoning why the liability is joint and severally? Both. You will not find the answer of this question in the bare act or any textbook. For this you have to think. You have to apply your judicial mind. Sir, law always protect creditors. No, this is not the reasoning. See, Aprajita, mark my words. For law, creditors or the debtors, both are on the same page, right? So it is not like that creditors or the debtors are the favored child. No, that's not. Okay? The objective of the court is to do justice. That's it. Nothing more than that. And nothing less than that. They don't clear so. Zara, you are close. You are very, very close to the correct answer. Anyone else? Amit, that's section 25 of Indian Partnership Act. We are not doing partnership here. I have not said that A, B and C are the partners in a partnership firm. So section 25 of Partnership Act will not come into the role here. Okay, now let me answer. Answer of Zara was correct. I'm just completing her answer. Why? I'm giving you the answer of why. See, what was the contract between the parties? What was the contract between the parties? The contract was simple and clear that the liability of ABC is of 30 lakhs. Now suppose while the contract was taking place, if A says that see my liability is of maximum 10 lakhs, Nothing more than that. If A specifies that my maximum liability is only of 10 lakh rupees, in that case, can you say the liability is several as well? The answer is no. But in this particular contract, all these three parties agreed that we are taking the liability of 30 lakh rupees. So tomorrow, if B and C goes bankrupt, they got insolvent, can A say that I will give only 10 lakh rupees? No, A have to pay 30 lakh rupees. So unless and until you have dictated in the contract that see my maximum liabilities of 10 lakh, 5 lakh or whatever the amount is, if that has not been specified and they promise to pay D 30 lakh rupees, then the liability of those 30 lakh rupees is jointly and severally. I hope the reasons are clear. I hope Zara also wants to say the same thing. Right, Zara? And if it's clear, quickly give me a thumbs up. I'll move to the next one. Even this is not joint or severally. This is joint and severally. ठीक है दोनों joint भी and severally. Yes, clear. Yes, Amit. If any of them absconded in UK, then the other will pay. So suppose if C absconded, right, in UK, then A and B will pay 15 lakh each to D. Why? Because they agreed for the 30 lakh, not for only 10 or 15 or 5 lakhs. Done? Coming to the next question. There is a contract between A and a shopkeeper. This shopkeeper needs to deliver the cake and A needs to pay the price. The contract took place on 29th November. Can this be a contract? Answer is yes. It's a simple case of contract, right? Now in this basically it's चलो I think ज़्यादा detail में हो जाएगा. This is basically agreement to sell. But okay, let's, as far as the Indian contract is concerned, we can say that there is a contract between the parties. Okay. Now, suppose the date of performance as per to the parties decided. So it was a birthday cake and the birthday was on 1st of December. The birthday was on 1st of December. So A said to the shopkeeper that please make sure that you deliver the cake on 1st of December maximum by 6 p.m. Okay, done. Now, this shopkeeper is delivering the cake on 1st of December, but on 11 p.m. Now, you need to tell me whether this will be considered as breach of contract, yes, or this will not be treated as breach of contract. It is a breach of contract, yes or no. Answer in the comments. Kanika, first one to answer. Yes, breach of contract. Okay, everyone is saying yes, yes, yes. Okay. Even Aprajita has mentioned the condition as well, the correct answer. Yes, students, the answer is correct. This is going to be treated as breach of contract, and yes, it's a breach of contract. Why? Because as per to the contract, see, the timing was essential. Why? Because if the birthday party was at needs to be started at 6 and you are delivering the cake at 11 p.m. Now this is not making any sense, and this will be treated as breach of contract. So basically the concept here is time. Time is essential when the parties basically enter into the contract of law. So if they have specified the time because it's important for them, and if the goods have been not been delivered at that particular time, that will be treated as breach of contract. Okay, next one. My next question is, answer this, students. There can be three circumstances. First, in case of void agreement. Second, in case of voidable contract. Third, in case of contract becomes void. And in this particular situation, if there is a voidable contract, it means it is at the option of one party, and that one party choose to make void agreement. Now in all these three situations, if there is any benefit that has been given to the party, any benefit given to the party, so that benefit needs to be returned, yes or no. If there is a void agreement, that benefit needs to be returned. If there is a voidable contract and it leads to a void agreement, benefit needs to return or not. And if there is a contract becomes void, you need to return the benefit, yes or no. And if you can write the relevant section numbers or the reasons, that will be an additional benefit to you. बताइए जी. In all these three cases, it needs to be written, or only two, or only one? In all these three situations, the benefit needs to be written. I have not got the section number till now or the reason. I'm giving you the answer now. Okay, one more question. After that, I'll conclude all these. Let's include the fourth situation as well. If it is a voidable contract which leads to a valid contract, now you need to return the benefit, yes or no. Now you have already answered about this one. Answer about this one. Benefit needs to return or not. If there is a voidable contract and the party whose at option it was, that party makes it a valid contract, now that benefit needs to be returned or not. Okay, I have got the section number as well. 64 and 65 is the correct answer. Section 64 and 65 is the correct reasoning, by the way, why you need to return the benefit. Kanika, first one to answer. Fourth situation, need not to be returned. Okay, Kanika. Sir, when valid, no need to return. Okay. What about others? Now let me conclude the answer. In all these three situations, benefit needs to be returned because of section 64 and 65. When it comes to voidable contract and the party make it a valid contract, then benefit needs not to be returned. Why? Because you have made that as a valid contract. Always do remember, now I'm going one step further than 64 and 65. Now you may face a question like this as well, that why under section 64 and 65 the benefit needs to be returned. The reason is because in all these three situations there is one concept which is common: void agreement. Void agreement, contract becomes void, and the term void means zero. Zero means zero effect. Zero effect means the parties will be returned to those positions which they were before entering into that void agreement, or contract becomes void or voidable contract. Because it is void, so it means zero. Zero means zero effect, means that particular agreement will not impact your life. And if you have taken any benefit, you need to return, which means the parties will come into that situation that was before coming into the void agreement. But if you are making it as a valid contract, then it's completely fine. The one party has already taken the goods, you have taken the price. It's a win-win situation. There is nothing which needs to be returned. I hope it's clear. If yes, quickly give me a thumbs up. I'll come to the next one. Clear? Okay. Next one is a very, very simple question. Next one is a very, very simple question. Just listen carefully and answer that. When it comes to contract, it is made by section number 10, so we can say it is the law. But again, when it comes to agreement, it is basically the parties that decide, right? Everyone will agree on this, that contract is made by law, agreement is made by the parties. Who is going to give the proposal, to whom the proposal needs to be given, what is going to be the consideration, all these questions are going to be decided by the parties only. But when it comes to section number 10, what are the conditions? Free consent, parties must be competent to contract, that must not be, there must be a lawful consideration, lawful object. So that is something which is made by the law. Now my question is, if this is the case, why do we need the concept of quasi contract? Why do we need the concept of quasi contract? Yes, please. What is the need? And quasi contract is something which is completely made by law. So if you can answer that, why do we need the concept of quasi-contract? Sir, to safeguard the person who is helping the person incapable entering. Okay. Kanika, you have basically written the meaning of quasi-contract. So basically, oh, not even the meaning of quasi-contract, you have written section 68, right? My question is, why do we need the concept of quasi-contract? Why there is, what is the jurisprudential essence of quasi-contract? What is the object of quasi-contract? And trust me, you all know the answer. I can tell you. You know the answer. The moment I am going to write the reason, you are going to be like, sir, we knew this. I have got the correct answer from Kirti, and there is only one word which I was looking for, and that is because of unjust enrichment. This is the reason. One party cannot take benefit of another party. And this is something which is common from starting from section 68 till section 72. In all these sections, there is one party who is, enriching, which is completely unjust. And there comes the picture of the role of law in the form of quasi-contract. And when we made that party liable, whosoever has taken unjust enrichment, to give it back to the party. See, I told you. Done. So the key word, see students, try to learn this thing. You need to focus on the keywords. Okay? So if you have now just assume, if you have got this question in your mains examination and you have written everything and all the valid points, section 68 says this, 69 this, 70, but you have not mentioned unjust enrichment, your answer will remain incomplete. Done? Yes, anything else before concluding this class? If it's all good, quickly give me a thumbs up. I'll wrap up the session now. Amit, your answer is philosophical. I'm looking for the key term unjust enrichment. Your answer is correct, but still, if you are not writing about unjust enrichment, then there is going to be problem. Done? अमित का आंसर पढ़ने के बाद तो मुझे लग रहा है फिर अमित को घर से ही उठा लेंगे वो, कि कहाँ थे आप अब तक, है अमित? चलिए जी, on that note, let's conclude this class. So this is the link of my profile, students, my Telegram channel, and this is my code Khatri10. It's an important information. There is a price drop alert for judiciary aspirants, which has been started from November 25th. This is available on both Plus and Iconic courses. So make sure you don't miss that. There is 24 months and 12 months. This is applicable on 24 and 12 months of both Plus and Iconic course. Okay, ji? You can use my code Khatri10 to get 10% off. There is a judiciary test series for December. This is the detailed one. This is the batch which has been recently started, Sarthi 4.0 from November 28th. This is Rajasthan State Judiciary batch, started from November 18th. This is the result from Unacademy for Rajasthan Judicial Services exam. This is the features of Unacademy Iconic. This is the YouTube and the Telegram channel of Unacademy. And that's it from my end. See you in my next class. Till then, yes, it's time to say peace.